If you read that will and you believe it does not reflect the wishes of your deceased loved one, then the only remedy you've got is to file what's called a will contest. In California, there are 6 different bases for contesting a will, and we're going to go through these one by one. The very first one of them is called due execution. And what that really means is it means that the will was signed properly. And California doesn't require very much. All California requires is that the person who signed the will was over 18 when they did it and that they were mentally competent. If you're the person who wants this will admitted, you've got the burden of proof to show those things are true. The second basis for a will contest in California is a lack of mental capacity. If you're the person who's claiming there's a lack of mental capacity, then you've got the burden of proof. And here's what needs to be shown. You need to show the testator, that's the person who signed the will, at the time they signed, didn't understand the testamentary act. Now that's legalese for meaning they didn't understand that what they were doing in signing their will was actually determining who it was that was going to inherit and what they would inherit when that will got admitted to probate. The second way of proving mental incapacity is to show the testator did not understand or remember the property that they owned. Now, this is just plain common sense. If a person literally does not understand what they have, and they are supposedly creating a document that says who's going to get it and how much they're going to get, well, then that's proof that that person lacked mental capacity. And the third way of proving that a person lacked mental capacity is to show that they did not understand the relationship to the family members and other close people in their life. And again, this is going to comport with your common sense. If a person doesn't understand that they're married, they have children, grandchildren, close friends, whoever it is that's still alive and still in their life, it only makes sense that that person doesn't have the ability to decide who's going to inherit their property when they pass away. An alternative way of proving lack of mental capacity is showing that the testator had a mental condition that gave them delusions or hallucinations, and it's those delusions or hallucinations that caused them to create the will that they did. In other words, they left the property the way they did because of their delusions or hallucinations. An example of this would be somebody who's afflicted with Lewy body dementia. That's a particular type of dementia that causes a person to hallucinate. So if the person is hallucinating people that aren't there, hallucinating threats to them, things that just aren't real, and so they create a will that is a response to these people that aren't there or the threats that weren't made, that's an example of how you can prove mental incapacity in this situation. The third basis for contesting a will in California is by proving undue influence. In California, undue influence is defined as excessive persuasion that either causes a person to act or stop from acting in a way that results in an inequity. Now, I know that's some dense legal language, but what it really means is this. It doesn't mean that the person who created the will didn't understand what was going on. It means that they couldn't exercise their own free will, and they couldn't do that because there's somebody else, maybe they took advantage of a situation, maybe they took advantage of some form of impairment, but they did something to make sure the person who was creating the will couldn't make their own choices. And as a result of that person not being able to make their own choices, somebody else benefited from that. There is no one right way to prove undue influence. There are any number of factors that come into play in a case like this, and they will include the vulnerability of the victim, the authority of the person who used the excessive persuasion, the actions and the tactics that were used by the person who was imposing their will on the testator, There's no one right way to prove undue influence. California law recognizes a number of different factors that may come into play to show that this excessive persuasion. Among the factors are the vulnerability of the testator. As you might imagine, somebody who is infirm or has some kind of mental impairment isn't really capable of meaningfully expressing themselves and exercising their own free will. And what goes hand in hand with that is the apparent authority of the person who is exercising undue influence. Other factors include the tactics and the actions that were actually taken by the person who is using this excessive persuasion. And finally, it's the inequity of the result. Is there really something wrong that happened as a result of the actions that occurred? Undue influence, though it's got a legal definition, is something that intuitively most people understand. If there's one person who's controlling another person and that results in an unfair result, chances are you can show there was undue influence. The fourth way of contesting a will is by proving fraud. And fraud in a will contest means that a person has been tricked into creating a will that they otherwise wouldn't have created. Fraud can take place in a number of ways. A person can be given a document not being told it's a will, believing that they're actually signing something else. It could be that the will that they're given doesn't contain the terms that they believe that will actually has. There's more than one way to prove fraud, but basically if there is deception involved, that's what you're looking at. The fifth way of contesting a will in California is by proving duress. Duress in broad strokes involves either the use of violence against a person or against property. So one way of proving duress is if you can show that a person has actually illegally confined another person in order to get them to create a will. Similarly, if they take control of the person's property and they won't release that property without the will being created, then that also is duress. And finally, if there's the use of confinement, not of the testator, but of a relative of the testator, that also is a way of proving duress. You should know that cases of duress are few and far between. The sixth and final way of contesting a trust in California is by alleging menace. Menace is simply the threat of duress. In other words, if you threaten to confine someone, you threaten to take their property, or you threaten to confine their relative, that's duress. Just like menace, duress is very, very uncommon. So those are the 6 ways to contest a will in California. And not every probate involves a will. There are probates where there is not a will. And when that's the case, the real question is who's going to be in charge? Who's going to be the administrator of the estate? In my next video, I'm going to discuss how you challenge the appointment of an administrator. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.